welcome to this morning's webinar. My name is John Marzola. I'm a partner here at the LOIS Law Firm, and we're very looking forward to speaking to you today about evaluating claims for exposure in New York. I hope everybody had a nice weekend. Hope everybody's ready for Thanksgiving and everybody's travel plans are set as we head into a nice short holiday week. Good morning. This is Tim Kane. He's my right-hand man, and why don't you introduce yourself?
Right, this is Tim Kane. I'm a senior associate here at the firm. My team and I primarily handle cases in Manhattan, Staten Island, and out on Long Island and Hauppauge, although I'm looking forward to handling claims all over the state with the advent of virtual hearings. This morning's
webinar, as I mentioned, will be focused on evaluating cases for exposure, and we're going to get into the different types of exposures and what that process entails. But remember, this is live, so please feel free to ask questions. I hope everyone sees that box that's popped up on your screen, and if you have a question, feel free to ask if something pops in your head along the way, and we'll try to get to as many as we can at the end.
Right.
Okay, so when we're evaluating exposure, keep in mind when judges make that final determination as to what this case is worth and what you're going to have to pay at the end of the case, they are going to use the disability duration guidelines pretty much as the heartbeat of their decision. There's a bunch of other things that go into it, but primarily in our experience, we've determined that what your medical impairment is, generally speaking, forms the majority of what that ultimate decision is.
Right, and when we do an exposure analysis on a case, at this point, we're assuming this is an established case. Of course, in the early life of a case, there may be reasons that you can get rid of a case for what we call a nuisance value, a lower amount. But once a case is established, depending on the sites that are established, we're going to be looking at it in terms of what the future exposure is, and that's why we're looking at the permanency guidelines.
Right, and there's really two kinds of claims in which the exposure for your case is ultimately going to be evaluated. We have the scheduled loss of use claims, and we have your loss of wage earning capacity claims. A scheduled loss of use claim is one that's limited to a specific set of body parts, those being the fingers, toes, hands, arms, feet, legs, and eyes.
Yep, you're looking at the extremities as well as the eyes. Anytime a case is strictly established for the extremities, or even in cases where the neck and back might be established, but the person goes back to work and they're not really milking it for that neck and back claim and they just want their schedule, that's a good way to get a finding of permanency and close the case down.
Right. And I found that the scheduled loss of use claims can be more direct in terms of calculating the exposure because there's less subjectivity that goes into it, and we're not talking about certain vocational factors. It's governed by the scheduled loss of use charts of weeks, where each body part is determined to have a set value for a maximum number of weeks you have to pay the temporary total disability rate.
Right. What you're looking at on the screen now is quite literally the schedule that goes into the scheduled loss of use determination. Like you said, John, once a determination of the percentage of loss of use has been made, whether that's by a judge or whether that's per agreement of the parties based on the doctor's reports, then it's a simple matter of doing the math. You take the indemnity credit, you take the gross number, and you figure out what's moving to the claimant.
Right. And before we get there, that being the end of the case where a scheduled loss of use percentage is assigned, we're going to want to make sure that the evaluating doctor, both the claimant's treating physician as well as our IME, are going through the proper channels to come up with that particular percentage, right?
Right. So particularly in a contested or controverted scheduled loss of use matter, not controverted, but when when the issue is joined, you want to make sure that the doctor, first and foremost, use the SLU guidelines, the permanency guidelines, when they come up with their determination. Sometimes a doctor will say on cross-examination that, I kind of made a guess based on 30 years of being a doctor, or
right.
I just picked a number out of thin air. And that's certainly an area where you can attack their credibility, because obviously these percentages are described in detail in the guidelines, and they're supposed to be using these guidelines when they make their SLU opinion.
Right, and I found that usually the highest exposure findings in terms of the knee and the shoulder in particular, the range of motion or the alleged range of motion restrictions generally what drives that bust in terms of the higher percentages we see, even in cases where there hasn't been a surgery. And what are some of the, in your experiences, Tim, what are some of the things that we can cross-examine claimants' doctors about to kind of attack those findings in terms of range of motion limitations?
Right. So, as you said, a big chunk of the determination is based on the range of motion findings of the doctor. So what you might want to do is look at the doctor's last few reports before that permanency report, or look at even a different treating doctor's most recent reports and see if the range of motions are different. If they suddenly walked into their permanency evaluation and their range of motion suddenly decreased significantly, you can cross them against their prior reports or against the other treating doctor's reports and say, hey, what's the story here? Why did his range of motion get so much worse when it came time to figure out the scheduled loss of use? Furthermore, the doctor is using a tool often called a goniometer, but if they don't use that or some other tool to determine range of motion, if they just eyeballed it, that's certainly something you can cross-examine them about and try and attack their credibility that way.
Right, and I think we also want to make sure that they engage in active as well as passive testing in terms of the range of motion limitations, right? Right.
You ask them, whether there was a subjective element to the claimant's effort. Usually, not surprisingly, the IME doctor finds a much greater range of motion than the claimant's doctor, although not always, but often enough.
Yeah, I actually have seen that sometimes, right, where the IME finds a higher percentage of scheduled loss of use.
Every now and then.
Yeah, and then you
get
in
that position.
Right, you get in that situation where you don't want to have to attack your own doctor, so usually the parties put their heads together and come up with an amicable resolution, somewhere in between the two competing opinions.
Usually, yes.
It makes for a more comfortable experience than saying to your own doctor, who's supposed to be on your side, hey, where'd you calculate? Where'd you come up with these calculations?
Right.
We don't agree with that.
Yeah, although both sides would have to be in that same position, so.
True, true enough. And on the scheduled loss of use, when you're going through the permanency guidelines with respect to the range of motion charts, we find that this is, again, lacks subjectivity. It's very black and white. Either the body part was able to reach a certain degree or it wasn't, right? Isn't that pretty much
right?
What you see?
And then you can take that exact degree of range of motion, plug it into the medical or the SLU guidelines, and it'll tell you what the percentage is. There's also, to be clear, for most sites, a set of special considerations. If there was a certain type of surgery or if a diagnostic showed a particular finding, there are additional percentage points that can be tacked on for those special considerations. But again, these are things that the doctor has to elucidate clearly in their report. These are things that you can cross-examine them on. They have to be documented. So, for example, if someone had a particular type of surgery, and that's listed in the special considerations, they might be able to tack on some extra points. If that particular surgery is not listed in the special considerations, then they won't. So you want to take a look at what's been happening, what's performed on this claimant, what the diagnostics say, and make sure that the scheduled loss use finding is appropriate.
Right, and we also want to make sure that whatever findings the doctor may have come up with based upon physical examination, that it's on the proper form, because it's not going to be acceptable for the exam to take place, for a finding to be documented, but then it not be on a specific form known as a C-4.3.
Right. Tactically, when the claimant and the carrier have been directed to produce permanency reports, the carrier just gets an IME as per usual. That's what the carrier usually produces. But the claimant's physician is required to produce that on a C4.3, and if they fail to do so, even if they don't think that the claimant has reached a maximum medical improvement, you can get the claimant's opportunity to produce a permanency report precluded by some judges. So that's definitely an argument you want to make if it's possible.
Yeah, I've personally found that although in a claimant-friendly world that we live in New York, there are certain things that judges absolutely make the claimants abide with and comply with, and getting those permanency findings on that C4.3 is one of them. For whatever reason, they seem to really stick to the report being on that form by a date certain. Maybe they'll give them a final opportunity if it doesn't come in by the first date they give them. But I have seen on a number of occasions in the past couple of months where judges have started to preclude the report and consequently make their decision on the extent of scheduled use based solely on the IME.
Right, definitely.
And we kind of touched on this briefly, but again, in the world of a scheduled loss of use permanency finding, it's always going to be the temporary total rate of compensation that the award is paid at. In other words, 2/3 of what the claimant's average weekly wage is, subject to the statutory maximum for the year in which the accident occurred. 66.6% of the average weekly wage, all payable in a lump sum upfront at once, of course, with the carrier taking credit for all prior payments made.
That's correct. Again, you just use that schedule. You take the percentage against the total number of weeks that extremity is valued at. You subtract the indemnity, and you've got your final number.
Right, and let's not forget about protracted healing period.
Indeed.
Kind of a dirty term from carrier's side, because that's a little unpleasant surprise you might have at the end of the case. And what we mean by that is that for each of these scheduled body parts, your arms, your legs, your feet, your fingers, your toes, there are what's known as a normal healing period, and for each body part there is a chart that there's a commiserate number of weeks that's considered normal. For example, the arm 32 weeks, the leg 40 weeks, and so on and so forth. It's all there in the chart. But what that means is that if you exceed those number of weeks for the normal healing period for each part, at the end of the case, you could be entitled, or you could be obligated from a carrier's perspective to pay however many weeks in addition to the normal healing period at the total rate.
Right. So practically speaking, that number of weeks has to do with the number of weeks of temporary total indemnity benefits that were awarded to the claimant. And so any carrier defense attorney is going to, in any case that looks like it's going to end up in a scheduled loss of use award, you want to minimize the number of weeks that are awarded at the total rate. So you look at the medical reports. If the claimant's doctor doesn't say 100% temporary total for any period of time, you ask the judge not to make the award at TT for that period of time. You look for a TR rate or a TD rate. You definitely want to try to minimize the number of weeks at TT. Same thing if you get an IME that says a partial disability. You want to get that case on calendar and get the rate reduced as soon as possible to try and avoid hitting some of these numbers, which aren't terribly large numbers. So it's I've definitely seen cases where claimants have been at total for a year, and it just gives a ridiculous boost to the final SLU award.
So you just made 2 points that I think are very important. First, remember, even if you're voluntarily paying the claimant at the temporary total rate, but there's no medical evidence to support an ongoing temporary total disability, or you're not under direction from the court to do so. Again, you're doing voluntarily with or without the medical evidence to support a TTD award. Remember, at some point those awards are going to be formalized, and if the medical evidence was not there to support the period in which you voluntarily made those temporary total payments, it's critical to request that even if the rate is not being adjusted, that it's a tentative rate, not right. Total, because those weeks will count against the normal healing period and could leave you with an extended period of protracted healing period payments. The other thing you said I think is very important. When you have a scheduled loss of use, established injury, and you have a surgery, very important to get an IME within 90 days of that surgery, because they're going to be entitled to at least that period of temporary total benefits, and you want to get into court as soon as possible and just get off TTD. No matter what the rate relief you get is, get off TTD as soon as possible when you're dealing with a scheduled loss of use claim.
Right, because all the weeks above and beyond that normal healing period are just tacked on to the ultimate schedule, and it can really significantly increase the exposure.
Okay. I think we covered a lot of things in terms of scheduled loss of use claims. Let's jump over to another type of claim and a different type of exposure, and that's when we're talking about loss of wage earning capacity claims.
Right. These are traditionally your neck and back injuries. It doesn't always have to be. There are cases where if you have, for example, the bilateral upper extremities are injured, you might get an argument for a classification, but for the most part, whenever the neck and back are established, that's when you got to start thinking about what are we looking at here in terms of LWEC permanency.
Right. And similar to scheduled loss of use claims, there is also a number of weeks that are assessed to a corresponding loss of wage earning capacity percentage. There is a delineated number of weeks for whatever range the claimant falls in at the end of the case when the judge makes that permanency determination, right?
Right, and these are awarded over the course of time, unlike a scheduled loss of use, which is characterized in terms of a number of weeks, but is usually paid out in a lump sum. With an LWEC, it's that's the number of weeks over the course of which the claimant will be receiving weekly or biweekly checks for indemnity benefits.
Right, and the other key difference here is, unlike scheduled awards, you're not getting the temporary total rate for those weeks. You're going to get the rate that's corresponding with the LWIC percentage, right?
Right, correct. So it's the greater the exposure. I mean, the greater the rate and the number of weeks. I mean, the exposure increases almost exponentially. So you want to try to make sure that you keep both numbers as low as possible.
Right. Right. Okay, and the way we ultimately get there, right, the day in which the judge said, okay, I've made up my mind, here's the loss of wager incapacity number for your case. The first thing that has to happen is that there has to be a finding of maximum medical improvement from both sides. And then from there, we can start talking about what the impairment rating is.
Or a finding of maximum medical improvement from one side, and the judge makes that decision. You can litigate maximum medical improvement versus further cause-related disability, or if both doctors concede MMI, then you just proceed with the
yeah. Well, it makes it nice and easy when both doctors agree that
right.
Today's the day maximum medical improvement has been reached, but we all know not all cases go like that.
Right, and even then, they're likely to have differing opinions as to the degree of permanent impairment.
Right. So, but let's imagine for a moment we're in a world, right, where the doctors are in agreement that we've had MMI. The next step is they have to assign a severity ranking for each classifiable body part, right?
Correct. And that's all per the permanency guidelines. There are a multitude of tables that the doctors can refer to for whether the claimant was surgically treated or not surgically treated, the type of complaints they have, whether they're with or without objective support. And the doctors can put them in the right table to determine the class and severity. There's also supplemental tables that have to do with radiculopathy. And they have to go ahead and calculate all the points, and those are areas that are ripe for cross-examination.
Right. And, the guidelines can get quite intricate in terms of all the various factors that go into a permanency finding. But I find that to be helpful. I think it gives us, as defense attorneys, a lot of tools to cross-examine the treating doctor's reports with and kind of poke holes in those reports if his finding is not aligned with those various tables.
Exactly, yep.
And the information also goes on a C4-3, just like in our scheduled loss of use claims, but there are some differences in terms of the various components that go into the report, most notably the functional assessment, where there are a number of physical acts and activities in which the claimant's doctor is compelled to note whether they can never do this, whether they can occasionally do it, whether they can frequently do it. And I have found that the advent of this report has been very helpful in making an argument that the permanency finding is not consistent with the various functional assessments that the doctor came up with.
Definitely. So if there's a concession on this section that the claimant is able to sit for long periods of time, for example, you could say, doctor, well, then couldn't they take a desk job? I mean, maybe this is somebody who had a very highly physical type job before they were injured, and if they're capable of sitting there, I'm sure they can also pick up a phone. So you can definitely get some useful concessions here. And just below this section, which isn't pictured here on the C4.3, the doctor is also required to indicate whether the restrictions are light duty, moderate duty, heavy duty, that kind of thing. So that's another area where you can really dig in on cross-examination.
Right, and it gets quite specific, right? Like what is a sedentary job? What is a light duty job? And I find that this can go both ways, right? Because the doctor is either going to concede you can do a light-duty job, which I find is very helpful in terms of getting the LWIC finding down, or they're not. They're going to say you can't do a light-duty job. You can do less than sedentary work. You can do nothing. You're so disabled it's a challenge for you to even get out of bed. But that's not the end of the story in a lot of these claims, because you can get a report in that looks quite concerning in terms of how disabled the individual is, but if if you have that person under surveillance either before or after the exam, there are ways to combat what could be a daunting C4-3 report.
Certainly. Anytime the claimant tells their doctor they can or can't do something, if they say, I can't drive a car, and then you have a video of them driving a car, then you start getting into the realm of maybe I can raise fraud against this claimant, and that's certainly a pretty powerful defense. There's also the as pictured here in the slide, if you ask the doctor if they performed a functional capacity assessment or whether the claimant would benefit from a functional capacity assessment, that gives you a number of different points against which to measure the claimant's claimed deficits versus what you can see in the video.
Yeah, I love when they say they can never drive a car, right? Because when you do surveillance, sometimes it's hard to catch them in a moment of, wow, we got a smoking gun here. This person is absolutely engaging in fraud. But you don't always get that great surveillance where you see them working or they're doing something incredibly stressful. But seeing people drive a vehicle is something that's easy to catch, right?
It's a yes or no.
It's a yes or no, and when they say no on that box, they've got a fraud issue right out of the gates. It's really the easiest kind of way to nail someone when their doctor's saying they can't drive a vehicle. That's why you'll see them say occasionally, right? Like that's the one they don't ever want to really give up because they know. Well, how'd you get to the exam today? Well, sometimes you'll see I took a bus, but that might be on a one-off doctor's appointment. But I think someone who drives a vehicle in their spare time is something you can catch that.
Right, and importantly, if you're going to go down the road of fraud, these have to be things that the claimant represented to the doctor or the claimant represented to the IME. If it's just the doctor saying it, that's not good enough. So you have to make that distinction.
Right. Now, you mentioned functional capacity evaluations. Is that something in your experience that we can actually force the claimant to attend?
I don't know whether any judge is going to force the claimant to attend unless, for example, the IME indicates that that information is required in order to make a determination of degree of permanent impairment, and even better, if the claimant's own doctor says that that's something that it would be useful in this case, and so you can ask for the judge to direct that. I don't know if every last judge is going to direct it, but it's certainly something that some judges will say, okay, you can go ahead and schedule that, and the claimant will attend.
Right, and I think, like you said, the key is that the IME says it would be helpful. And in order to kind of nudge that answer out of them, I think it's a good idea to serve them with a cover letter, right? A good cover letter in advance of the exam in which we pointedly ask our doctor, would you find a functional capacity evaluation to be helpful in forming your opinion?
Right, you definitely want to get the right information out of the doctor across the board, so a good cover letter can always help with that.
And also asking, I guess, the treating doctor on cross-examination, would that have been helpful? They're usually not going to concede that, but you never know what they say.
Yeah. Sometimes they do.
Yeah. And remember, when arguing a LWIC case before a judge, they're going to use that medical impairment as kind of the heartbeat of their opinion, but that's not where the analysis ends. There are other factors that go into the judge's decision, or at least there should be.
Oh, most definitely. You've got the vocational factors. This is where the claimant testifies. So up till now, you've been cross-examining the IME doctor. You've been cross-examining the claimant's doctor. You've taken testimony of the IME doctor, and the judge gets a pretty good idea, hopefully, of the degree of medical impairment. And then it's time for the claimant to sit down and testify about vocational factors. These are things like the level of education they have, their English speaking, reading, and writing skills, any particular training that they've had, what they've done in their career leading up till now. And that's a lot of really ripe area, again, for cross-examination. If somebody, again, was injured in a very physical job, but they worked for 15 years before that as a bank teller, you could say, well, is there anything stopping you from going back to that work as a bank teller? It's something you're clearly capable of. That's just a hypothetical. But that's definitely an area where you can really dig in, particularly if you have from the employer the resume that the person submitted to check against what the answers that they put on their vocational factors form. If you have information from their personnel file, if you have potentially even an employer witness who can come in and testify about the kind of things that this person is capable of doing on the job, above and beyond the obvious descriptions. If they were on a management level and they oversaw a dozen people or 24 people, and they had to deal with all kinds of issues above and beyond the brass tacks of the job, that's the kind of information you want to get in front of the judge.
Yeah, and I think also good to ask about social media, right? In this age, vast majority of claimants, they're going to be somewhere, whether it's Facebook, whether it's Instagram, and asking them how much time are they in front of a computer. They may deny it and say none or limited, but there are ways to secure that information and present them with it.
Right.
And make an argument that they're able to do other things other than just lay in bed all day and nurse themselves back to health.
Right. These days, it doesn't seem terribly credible to me when someone says, "No, I've never used a computer. I have no idea how to use a smartphone." But you definitely hear that, and so if you can objectively prove otherwise, that could be helpful to your case.
And just following up on a point we made earlier, remember it's in evaluating the exposure, from a numbers perspective, it's going to be rate times number of weeks equals the exposure, and then plus the cost of medical.
Right. When you're doing an exposure analysis, there's this sort of amorphous, tenuous future medical cost question, unless you have an MSA, and then it becomes a lot more concrete, and hopefully the MSA isn't too damaging. But other than that, you kind of have to take a stab at that future medical number.
Okay. Well, I think at this time maybe we'll open up to any questions, if you have any.
Yeah, so we've got some questions. I got a question from Leonard here.
Oh, really?
He says, knees! Exclamation point. How can we move a knee to a schedule when the claimant refuses to have surgery, for example, total knee replacement, and the judge stands on no maximum medical improvement reached? So essentially, what do we do to get to close out a knee case when they're refusing to get surgery? And I think you should try to restate the question because maybe people can't hear me.
Right, so the question is, in a knee case, and I suppose this could apply to any body part, but the question was specifically with regard to the knees. If the claimant has had surgery recommended but refuses to get it, surgery that would presumably get them to the point of MMI, heal them up and get them better, but they don't want to have it for whatever reason, can they just rely on this interminably and just keep the temporary benefits flowing on an indeterminate length of time because they refuse treatment?
Absolutely not. And you see that more than you think. Because I think when the rubber meets the road, some of these injuries maybe not be quite as serious, right? Like, can you imagine that scenario, Tim, where the injury is not as serious as the claimant and their doctor says it is? I know it's hard to believe.
Hard to believe.
But sometimes when they're pursuing this case, right, and their doctor's saying, you may need surgery, and they may take it as far as requesting authorization, and maybe the IME concedes it's necessary, maybe not. But at the end of the day, if the judge determines it is necessary, ultimately they have to have it. Or they're going to be determined to be at MMI. If they're going, they'll give them 90 days. They may even give them 120 days. But I've seen that a lot where they ultimately determine they're uncomfortable with surgery, they don't want to have it. And once their doctor admits that on cross-examination, that's the time where you ask the question, well, doctor, since if he's not going to pursue surgery, would you agree that he's reached maximum medical improvement? And at that point, they're basically boxed in, they're cornered. It's a yes or no question. And at that point, in my experience, I've found that that's the point at which the doctor will say yes. If he doesn't want to have the surgery, then MMI has been reached. And then you would follow it up with like, okay, well, at that point, what would you assess for a scheduled loss of use? You'll get a percentage that way. And that's generally how that would go. I don't know if you've had a different experience.
No, I think you're right. I mean, it may take more than one round of litigation. The judge may find the first time around that they find the claimant's treating doctor to be more credible and this person is a candidate for surgery. But if you come back 3 or 6 or 9 months later with a fresh IME and the same stale argument from a claimant's counsel about this person needs surgery and they haven't made a move, your argument becomes a lot stronger over the course of time. And as you said, you ask the doctor, look, if he's not going to have the surgery, are we at MMI? And usually that'll be yes, and you can make that argument to the judge. And obviously, if need be, you take that up on appeal.
Right.
All right, let me throw another question out there. A couple more on SLUs. Let's answer them maybe offline. Here's a good one. When looking for the injured worker on Facebook, should employers do the social media checks or should they use a surveillance firm to do that?
Want to restate the question? I don't know. Did everyone hear that, do you think?
So when looking for...
No, I mean, we'll restate it on this end. Yeah, the question is whether when you're looking at someone's social media presence, whether it's preferable for the employer to just go ahead and dig in that manner, or if you should have a surveillance firm do it. What do you think, John?
I think it's okay for the employer to, look for it, and if they see something that's out of line with what the medical reports have been saying, I think it's probably best course. Let your attorney know about it, and at that point, we would make a recommendation. I guess if you hired an investigator to follow up on what they see and start surveillance based upon what's being captured on Facebook, that's probably going to be the route you're going to want to go. But I have no objection whatsoever to an employer doing their own background check. This stuff is very easily findable. I mean, I guess if they have certain privacy settings, it might be more challenging. But even then, you are able to cull some information from just a general Facebook social media search.
I think there's an important distinction which should be made with regard to social media, which is that if a lot of people make their pages or their presence freely available, publicly available, and certainly anybody can go ahead and present that information to a judge if there was no expectation of privacy. But on the other hand, if a supervisor knows that one of their employees was good friends with the claimant and says, "Hey man, you can see his Facebook page, right? Can I just take a quick look at that?" and they pull the information that way, that's a no-no. So you're going to want to be careful about how you get the information. It all has to be above board.
Right. Okay. We're just about out of time here. If we didn't get to all your questions, we will answer them by email. And all our information is on the website, both Tim and I's specific email addresses and phone numbers. You can find it right there. And we'll get back to you as soon as we can. Our next webinar is Monday, December 17th. We'll be talking about reimbursement and subrogation in New York, talking about Section 29 liens and the Burns and Kelly calculations.
Oof, can't wait.
Yeah. Bring your calculator to that one, Tim, okay? Well, listen, everybody, thanks for joining us today. I hope everybody has a happy and healthy Thanksgiving, and we'll see you next time.
Take it easy, everybody.